Yeah, thanks for coming. So actually the anecdote is Philip and me met in the staircase because we were living next to each other for almost 2 years. We mostly talked about broken heatings and like all other kind of things you need to talk about when you live in the same staircase. And at some point, unfortunately a bit too late, like just before I moved out, realized that we're pretty similar spaces, which was an interesting coincidence, and now see each other actually much more. So yeah, honored to have you here. Philip is for me the one guy I call when I have any questions about AI regulation. I think you've been like very active also in the last like 1 or 2 years, obviously also before but especially in the last 1 or 2 years when it comes about the UAI Act and AI regulation, very vocal about it. You're in all the details, strong opinions, in a lot of good directions also, and I always really like the discussions with you. So very much looking forward to tonight. Philip will give a quick overview at the beginning. He brought a few slides just to bring everybody on the same page, and then we will have a bit of a discussion around the topic and then also open it up for questions. In general, if you have a remark, see something very differently, want to interrupt on a certain point, just raise your hand. Like, we don't have to wait until the question section. So I think it's even greater if there's something you fully disagree with, or you want to make like a remark and you feel like it's interesting for other people here as well. So with that, over to you, Philip.
Great. Thanks so much, Rasmus. Thanks, Siv, for organizing everything. Thanks for having me again. It's always a pleasure to be on the campus. Really great atmosphere, cool ecosystem, and
we can also sit, by the way.
Yeah, sure. I'm going to do that. Just a sec. Thanks. And so we thought about starting it off with a few of my 100 slides that I brought, and I can do some more later on if you want to. But let's see if this works on Zoom, and in here, yes, it does. So I just wanted to make a point in the beginning to show you a little bit that obviously it might not be the case that everybody around here is a qualified lawyer. Raise your hand if you're a qualified lawyer in here. There are some. Okay, so I got to watch my words. All right. But the point is that actually, of course, AI regulation and the AI space around everything that revolves in law, ethics, and so on is much broader than the AI Act. It's actually much older than the AI Act. And the AI Act ties into this system in a fairly imperfect way. This is something we could also talk about. We just, before we discussed what we're going to talk about, and we noted that we needed about 10 hours for our discussion. So we're going to try to limit it to just a little bit, basically just these few points that we want to raise concerning the AI Act and what's denoted as the PLD here. Does anybody know, sorry, what the PLD is? Can anybody imagine what that is? It's yeah. Right, it's the Product Liability Directive. And what's in it? Well, oh, yeah, that's interesting. So this guy, who is a qualified lawyer, apparently, said that if a product is defective, then it is assumed that it's the fault of the producer. Now, if this was a bar exam thing and we had been talking like, say, 2 years ago, I would have said, total fail, go out, But actually, he's right. But because, as we will show you in just a second, that's really one of the major game changers right now in the AI regulatory space. We have the AI Act, but we have this other piece of legislation, which is the Product Liability Directive, which has been updated to also apply to AI, and it brings with it this funny reversal of the burden of proof. So how does this work? Let me just show you in one slide very quickly why I think that people who are trying to build AI systems or integrate or use AI systems should at least have one person or better a team that look at compliance aspects. We have here the AI Act with fines of up to 7% of global annual turnover. Now that's a lot. You won't be hit that hard on your first trial or first mistake that you make, but it is certainly something that we haven't seen before, So anti-competitive practices, that's up to 4% global annual turnover, and that's already pretty massive. So 7%, that's really a lot. But what's actually perhaps more important from a practical perspective is this thing here, the reversal of the burden of proof. Actually, when you're running software right now, it was for a long time unclear whether the Product Liability Directive applies or not. Now, that is being updated at the same time as the AI Act. And it means that if you are an AI provider, so meaning a company that develops AI, or you're a company that's not even developing AI, but you're merely integrating AI into your final product, your end product, then you are supposed that you're qualified as a product manufacturer. And the product manufacturer, that is the person that's going to be held liable if something goes wrong. And basically, before, in the good old world, the victim, the injured person, needed to show that the product was defective and that the defect caused the accident. So, for example, we have that neat bottle of water here, and that's one of the famous cases from the BGH, you know, the German Federal Court for Private Law, that such a bottle exploded in the hands of a consumer. And then you have to show that this bottle was actually defective. That it wasn't you who dropped it or accidentally, you know, set off a firecracker inside, but rather that it was defective from the outset. Try to show that. I mean, it's really difficult, right? And now try to show this with AI. You know, you imagine something hits you, like the lawnmower that goes astray and it hits you on the whatever, or the autonomous vehicle. It's really difficult to say, you know, this was caused by, you know, line XYZ or that part of the tensor or whatever. So that's why in this new product liability directive, there's going to be this reversal of the burden of proof for much of the AI, for basically any AI-related scenarios, machine learning-related scenarios, whereby the producers have to show that they were not at fault, that the product was okay. How do you show this? Well, you got to document everything you're doing, basically. And there's even more to that. The injured person can come to your company and say, hey, I have a plausible case. I have a plausible case of having been hurt by an AI product. And hence, you please give me your data and your models. And I want to check if there's a fault in it, if there's a defect in it. Then you can come back and say, hey, this is all IP protected and, you know, trade secret and so on. And there's going to be some meddling and a lot of litigation. But just the fact that there is this new tool is a bit like a pretrial discovery in the US. And this is something we had not had in Europe before. And this is a major game changer. Okay, so that's this. And real quickly, just to tell you that, of course, then there's copyright, there's personality rights, there's GDPR, all of this stuff that you all know about that already exists out there, has been out there for quite some time, and that hasn't changed. That applies, of course, to AI providers, but also to mere AI users, right? So that's kind of the difference between product liability and AI Act. That's directed toward those who are engineers, who are developing, or who are developing projects that they integrate AI into, and the rest is for the users as well. And maybe just this, real quick, this slide about the new liability regime, just to make sure that everybody's on the same page here. There is basically these two pillars. One is product safety, and this is what in the EU you have for elevators or for toys or all kinds of things that you can only market, they can only bring onto the market if some product safety regulations have been fulfilled. Think TÜV, you know, for your car. But that doesn't answer the question of who's going to pay if something goes wrong. And that's what the product liability regime does. So those are two separate legal regimes. They're intertwined, but they're still separate. And that's what you have to distinguish. Now we have the AI Act, which is basically the product safety side. And then we have the product liability side. By the way, AI Act, see, it works, it's for toys, and it's also for autonomous driving. Raise your hand if you think that, you might know that this is mainly for high-risk products, right? So AI Act is mainly for high-risk AI products. What is a high risk? Is it the toy or the autonomous driving? Who's for autonomous driving as a high-risk product? Raise your hands, please. No abstentions. Okay, who's for toys? Seriously? Well, you're right. So it's the toys who are high risk under the AI Act, and autonomous driving is not high risk under the AI Act. Don't ask me why. Well, you can ask me why later on, but it's a funny fact, and you see that sometimes can be pretty counterintuitive. But you know, toys might explode and kids swallow them, and I don't know what they do with AI. But anyway, so it's just one fact that that it's geared toward certain sectors, and we talk more about what this affects. And there's a couple of, these are the product liability directive, there's another directive. And then basically, if you violate the AI Act, then very likely you're also going to be held liable under these regimes. And last slide, what's the structure of the AI Act? Just for those who have very rarely heard about it, and most of you will know this, but there's prohibited AI practices. It's basically Chinese style social scoring, but also RBI, remote biometric identification in public spaces, which is something that people were very worried about and that we can discuss at length. So this is something that was the one issue that almost killed the AI Act in the end, together with foundation model regulation. Then we have high-risk regulation. For all the high-risk sectors, you basically have to follow best industry practices that are made mandatory now. Then we have limited risk, which means if you introduce AI that's facing a consumer that interacts with human beings, you have to make this transparent. Same for deepfakes and stuff like this. And you have minimal risk, where I used to say, well, this doesn't bring any changes to anything. But now we have a new Article 4, which says that even if you run AI systems that are not even interacting with human beings, well, whatsoever, but you're just running AI, you need to have AI literacy training for every single person that interacts with this in your company. You need to have AI literacy. And that's actually quite massive, So you not only need you have a person monitoring this that is competent, but also everybody who's dealing with AI needs to be literate, which is why we're doing this tonight. So thanks so much for listening to this very, very short introduction. And
yeah, I guess now everybody's on the same page. So let's get right into it. So I think I want to discuss a few things. Like first, talk a bit about the AI Act in a bit more details. Then what does this practically mean for me as somebody developing AI products or using AI products? And then talk a bit about Outlook. What are kind of future topics and what might be other topics you are working at around more from a research perspective, which you think become important down the line. So maybe just like looking at it like high level, like do you think it's a good piece of work, the AI Act? Do you think it's a bad piece of work? What parts are done really well? What parts are done not so well? Because I mean, there were a lot of debates in all kinds of directions. So let's maybe skip the part like where all the detours were in the last couple of years, but like really let's focus on what's now the result.
Well, it's perfect. Of course, it's great. It's of unseen beauty. And have you read it in its entirety?
Yeah, I like page 74 to 77. Those were my perfect.
Yeah,
I read it a few times.
83, 3 is my favorite. No, I mean, it's I think I'm not happy with it, I have to say. I think in the end, and I've also been quite vocal about it, I think it's better to have it than not to have it, but for the wrong reasons. I think that and on the other hand, it's very far away from a really good result. Why this? So why is it better than nothing? That's precisely because of these issues that have little to do with economic applications, but with human rights protection. When we think about RBI, remote biometric identification, basically police and prosecutors' offices using AI in public spaces to identify persons, that's where we need, I think, we need very clear red lines. We need to make sure that we do not import any kind of Chinese-style, Russian-style surveillance regime, which, after all, of course, is something you can use AI for. And it's very clear that most people in the EU don't want that. And the AI Act has rightly been criticized as being too lenient on this, but at least it has some minimum protection. Without it, you would have even less. So that's one thing. I think we would need much more than that. If you think, some countries that have in recent past had quite some trouble with following the rule of law, think Hungary, they now will have a dedicated authority looking after the Hungarian police, for example, and it's difficult to say if that Hungarian authority is really going to do a good job if they try to single out opposition leaders. So that's one thing it's good, but it's still disappointing. On the other hand, it's doing way too much, I think, on some of the areas where we absolutely do need more AI. So all of this is called a high-risk area, and you've been very vocal in saying this. Those are the areas where actually we need AI a lot. It's medical, it's education. We have a shortage of skilled labor and everything. Of course, we need AI that's made in a good way. But we would have had other ways to do this, I think. And here we have quite a lot of red tape that is going to be difficult to handle for SMEs. And that's the final layer down here. So this is general purpose AI systems, basically foundation models, generative AI, that has a separate section for being regulated. And I think that's where you would have to have more teeth in it, where you could put in, where we would need to put in more clear AI safety features to make sure that some of these systems are not abused for, generating malware for bio and chemical threats, which unfortunately researchers have shown, can at some point be generated. And that's where the AI is also fairly lenient. And so I think it's just a funny mix, whereby on the one thing that it's really important, surveillance, it's too little. And on the other ends, and also on general purpose AI systems to a certain extent, whilst on the front of, just general high risk management, it's just maybe a little bit.
How do you generally see, I guess, this balance between, I guess that was also some of the challenges now of like being a technology regulation that is kind of use case agnostic, if you think about the general purpose AI system side, versus like trying to be very use case specific and, even categorizing for certain industries into like certain risk areas? Like, is there right or wrong, or is it good that it's a mix of both? And also related to that, I guess, especially about the application areas, and also actually on the technology things areas, like things will evolve over time, right? So the question is, how can we adapt this to new use case that maybe not in the annex down the line? Like, how can we make this dynamic?
Yeah, those are all excellent questions. So you might know that I might just pull up the slide where you can see some of the high risk use cases, and that actually has two different angles. So one high risk use case is listed in Annex 3, and that Annex 3 contains all kinds of these high risk, high reward areas, such as, let me just share the screen right quick, such as everything related to biometrics, but also if it's not forbidden because it's in the public sphere. But then also many areas that are really highly relevant in economic settings, so education, employment, medical creditworthiness, and also insurance, life and health insurance. And then you have some areas that are, more for a state perspective, like social benefits, judiciary, elections, that are also considered high risk. So this is some area where I would say there is room for improvement. For example, like putting everything in education really as in high risk. For example, I would say that's difficult because we have a real shortage of teachers, for example. It's really tough to get up to speed with the kids and everything. Of course, it needs to be done well, but we have the GDPR in place. But at the same time, it's going to be tough to, actually build AI education tools if that falls into the high risk category. And there's quite a bit of red tape attached to it if you're not Google or Microsoft. And then there's these practices that are not included. And those are some of the really, the core, that's basically the core of the digital society and of digital economy that is based on AI. That's everything related to e-commerce search engines and stuff, where of course all the queries are handled by AI systems. They're retrained on a daily basis, and that's not even included. So that's interesting to start. And I think that, and we've been, talking about this for years, like Rasmus and I, or at least during the years of when the AI was created, and we were always pretty clear in saying, it needs to be use case specific, because AI is not AI. Of course, you can use it for all kinds of things. But I do think that it makes sense to have that one exception for general purpose models, precisely because they are foundational in a sense that you have, you will integrate them into all kinds of different systems, basically like a new Windows or Mac, operating system. And if you can't fix one thing at the source, then you don't have to fix it 1,000 times in all the application. I think that makes economic sense to the extent that it's possible. And there are some people in the audience who perhaps know better than I do whether that's possible. But so I think that is actually something that breaks out of the usual structure of the architecture of the AI, but for good reasons. And then the last question was, how to make it dynamic, future-proof. And actually there, the commission can adopt acts to amend the annex and also the threshold. So within the foundation model regulation, you have two different layers. There's the layer for all foundation models, and then there's one for only the systemic risk models. And those with systemic risk, I can show you a different slide just real quick. Those with systemic risk, those are calculated. So you have foundation models, all foundation models, they have to comply with some transparency provisions, basically showing what they use in terms of data sets, also showing this to their customers to make sure that they can actually gauge whether, you know, it was trained properly to a certain extent. And then there's these copyright, 2 copyright provisions with a copyright compliance regime. And then for those with systemic risk, there's some AI safety features that are just best practices from industry, like risk management, red teaming, incident reporting, cybersecurity, that are made mandatory, but only for those with systemic risk. Now, what would you say of the models that we know that are out there, that you know for generative AI models, foundation models, which ones would you say, just off the cuff, which ones could constitute systemic risk? You think about it, could induce large scale, you know, problems on a societal level. All of them. Yeah, all of them. That's, yeah. Any people who would exempt some of them? All of them? Did somebody say all of them? Okay, good. So we have different opinions on it. But I think that the funny thing is that now in the beginning, they wanted to apply this provision to only models with more than 10 to 26 flops, which basically would mean no existing model, quite likely. And then the European Parliament came back and said, hey, let's make it 10 to 24. And then they sat down and said, basically, I guess they said, let's meet in the middle, which obviously is not the middle because it's a logarithmic scale. But so it's 10 to 25 now. And that means basically it's only GPT-4 and perhaps some of the latest, you know, Gemini and so on. But if you have like anything below it, ChatGPT, like the Mistral and so on, despite the fact that they're extremely powerful already, and don't even mention, you know, Llama and so on, they're not covered. And so I'm saying, hey, come on, guys, cybersecurity, you know, have you noticed that we are in that Europe is at war? You know, have you noticed? There are millions and millions of euros lost every year for cybersecurity and extortion. And if you build a foundation model without proper cybersecurity measures, I mean, this is absolutely crazy. Of course, there's a market pressure for that. But still, I mean, not having this for all models seems totally crazy to me. So this is kind of a bit funny, this system. And then the question for all of those who are dealing with this is, well, you know, those are only the rules for those who develop these models. But what if I'm fine-tuning the model, which is like the most common, I think, way to use them? You know, it's not that everybody in here will be training their own foundation models, I suppose. But rather you using some model and then you're fine-tuning it with your own data or something. Does that make you a developer of a foundation model? And so this is something, and I see Jared here. So from Jared DeMello, who's actually a very well-known Gen AI researcher from Hasselplatten Institute. And we talked about this before a little bit and made some proposals about exempting fine-tuning from the provision that says if you make a significant change to a model, then you are considered the developer. And then you have to comply with all this stuff. And that provision, that proposal did not make it into the final act. I don't know why. There was a lot of time pressure at the end, and I somehow happen to know that it was considered, but it didn't make it in. So now we're faced with this problem. You know, you're fine-tuning this on a data set. Does this mean that all this applies to you or not? Nobody knows. Hopefully not, but, you know, unless you do real crazy stuff. But that's a bit of, you know.
But maybe let's make it very practical. So like, say you are developing right now a foundation model, like what does this now in practice mean? Like maybe talk a bit about like, you know, timelines when regulation will put in place, when they're applicable, but also like make it very practical. Like, yeah, what do you actually have to do?
Yeah. So I think the first, let's talk about the timeline first, perhaps. So timeline is of course crucial because the AI will now, and I'm absolutely 98% sure that it will be adopted sometime April, May. Then it goes through a linguist check and so on. It will be published in the official journal, I guess around June or so. Then we have a staggered transition period. if you want to produce and use prohibited AI, please do so within the next 6 months, because then the prohibition will kick in. And prohibition, that's the stuff with the 7% fines, and rightly so. Then if you're a foundation model provider, 12 months after this, so this means summer 2025, the foundation model rules will apply. Then 24 months after the summer, so that means summer 2026, most rules on high-risk models will apply, namely those in Annex 3. Those that we've seen, with employment and medical, and not medical, sorry, employment and stuff. And then there's some specific exemptions that were for areas that are already highly regulated, such as medical AI or toys, where it only applies like 36 months after the entry into force. Now, what does this mean in practice? I think in practice, it means two things. One is that you have to be cognizant of this pipeline of things where you have to do all kinds of funny different things in different steps of the pipeline. Here, I have it here basically. So you have to make sure that you have a data governance regime in place, that you have a human in the loop, or that you make human in the loop possible, that you have adequate performance measures, robustness, security checks. All of this is, standard stuff for any AI developer. And you have a risk and quality management system that's iterative and that does check, and you make sure that people know that, and you document this, that all of these risks are addressed. And I think the most important one then really is here up in the middle, this transparency and documentation. Because, and that's mainly what's creating also red tape, because you will now be in a position where you need to disclose a lot as a developer, and you need to document it for your own best. Because remember, from the product liability directive, if something goes wrong, you will be called upon to say, look, guys, I made all the good choices. I made best efforts in actually designing the product as safe as possible within the constraints of, making it useful. And basically, that's what you have to show. So at every major step along your pipeline, you want to note what you do, and you want to note down just 2-3 bullet points, basically, why you did this. So that later on, when a court comes and asks, why did you do this? Why didn't you do this other, some expert says you should have, developed a differences. You should have used, I don't know what, a difference architecture, not a transformer model. You should have used, I don't know what. Then you should be able to say, hey, guys, we thought about this and we opted for this for these and these reasons. I mean, that's the ideal strategy.
I mean, that makes a lot of sense, but I guess if I see this slide and now read the UAI Act, it's still like, a lot of this stuff is still like very abstract. So like what's, I guess, happening in the next couple of months in making this more concrete? And do you expect that the concretization of this will give any developer of AI products enough like details how to make this or happen? Or is it then also a bit more of a trial and error, like being reasonable, documenting things, and then seeing as first court cases come up to figure out what is right? Like,
yeah, it's a bit of the latter, I guess. So one thing is that you can try to adhere to industry best practices that are out there, like the NIST framework from the US. That's not officially part of the AI Act, but if you use the NIST risk management framework, or MF, that's a pretty good start. And there are initiatives underway which will now make this hopefully more concrete, and that's via technical standards. So this is going to be a huge, the main, I'd say, transmission piece between those still rather abstract norms. See, they didn't even manage to put in performance metrics, but rather accuracy, which is the wrong metric. For example, for medical AI, you use accuracy with medical AI, just gets totally awry. So this is still legal lingo, basically. What does it mean to minimize bias? Yeah, everybody wants to minimize bias. What does that mean, right? In practice, what kind of metrics do you want to use? So this is what hopefully these standards are going to deliver. So it's ISO and Sensenelec standardization organizations that are going to be developing this, hopefully until the AI Act applies. And then you have guidelines that will be issued by the Commission and by some of these structures. You have the AI Office, the European AI Board, that are tasked with developing guidelines, basically, for people out there. And I hope they're going to be fast, and they're going to be using a lot of examples and a lot less legalese lingo to make sure that people actually know which side they're on.
Yeah. So I guess it will get more concrete, and then people can use that. But there's, I guess, some trade-off that if it's too concrete, I mean, as you know, these random thresholds, especially if they're set like you just mentioned, quite like a negotiation, that it could be that there's a lot of random parameters that need to be matched, that A might not make sense, plus B might be a bit use case specific, plus C might be outdated. So how do you think they will navigate this challenge? I mean, I think even if you get the best people in the room in the AI space, they will also not come up with something like very easy, simple that makes sense, just because it is so complex and so dependent on things. So where will this land? Or will this continue to be vague, and then it just ends up in litigation land, and like, you know, people will go to court, and then in like 10 years we will know what is kind of a reasonable correctness on minimizing of bias? Like,
unfortunately, yes, to a certain extent. So I think that, but that's a problem with, that's not specific to AI.
Yeah.
You know, you have this with everything from you know, materials that you use on children's playgrounds to whatever, everything, particularly with technology in it. You're never going to have the perfectly fitting legal piece. It would be outdated the day you publish it if it's too concrete. And if you make it more vague, there's some strategic vagueness in there to make it adaptable toward future developments. But that also means that there is leeway for interpretation. Yeah. And that's why people in the end have to hire lawyers. I mean, not myself. It's not self-propaganda. I'm not a lawyer. I'm just a legal scholar. But, you know, it's like, in the end, if you want to be on the safe side, you really need to ask a lawyer. And I think that's what a lot of companies will have to do, or their compliance teams, and basically make an educated guess based on the resources that are out there, the guidelines and the technical standards about how this applies, and write this up in a 2-page memo with bullet points why they think this is the way it applies to them. And then the judge will be, I think, hard pressed to actually second guess this, because if judges are people in the end, and you have to basically tell the judge, look, I'm reasonable. I didn't do this just to make money out of nothing. But, you know, I wanted to bring innovation and certain degree of safety into a good balance. And there's no perfect balance. Otherwise, you wouldn't need this. Yeah. And in the end, it's going to be a game. Yeah.
And how much work is this, right? Like, I mean, if you think about a 10-person startup, you know, you're developing an ML pipeline for any application, and, you know, a lot of these things, I guess, like, relevant for pretty much any application you're looking for. So, I mean, on the one hand, this could be really, like you said, like a 2-page memo where in the end you just like almost like a template, just fill in a few things and then like add a few things, and then it's done. And it's like a very quick thing, and you update it as you update your models and data sets, and you might even automatize that to automatically fill it up. And so that way you are always up to date with your documentation. And the other extreme could be like, you know, you're 10 people and you burn like 10% of your money on like lawyers and like, you know, reports and compliance people and some external consultants, and like, then, you know, that's the, like, where do you think we sit, on the one or the other extreme? Or again, it's very use case specific. What's your sense of, not now, I guess now there is a lot of uncertainty, but like looking at this like 12, 18 months down the line, when there is a bit more convergence and more people have kind of created these like documentation, that it will converge quite quickly to some standards.
Yeah, I think of course there's going to be a lot of room for hiring a lot of lawyers, and they're going to be writing a lot of checks. That's for sure. But I think you can try to do it in a lean way if you have some risk appetite, because it will just depend on, with so many other things, on your appetite to hedge risk or to take risk. So this is just a legal risk. And if you have, you know, one person in the room, and Julia wants to say something about it, I think that's great. But I think you can do this actually with a small team, with one, you know, with perhaps one person that's in charge and running a memo. And then, but that person has to be really good and, you know, keep updated and keeping, you know, stays informed. And if some ruling comes along, then you might have to change. You might have to set up a whole compliance system. And for example, and that's only for the AI Act. So remember this chart that I showed in the beginning, where we have all these different acts, and then it becomes a little more complicated, because you also need this for the copyright, you also need this for the GDPR, Yeah, and then it could get a little shaky with, you know, one person with half knowledge of, you know, having listened to our talk just today or something. Yeah. So I think in the end, it is going to be substantial. It's not easy. People will have to invest in this, and whether it's more like one person or 10% of your starting budget, that future will tell. Hopefully, it's more on the lower end. But maybe let's give Julia the mic. She's but maybe just introduce yourself.
Yeah, hi. My name is Julia Reinhardt, and I'm a fellow with Philipp, actually, at the European University School of Digital Studies, and also hosted by AI Campus. So actually working with both of you for the last 1.5 years. So I just wanted to make that point because you were mentioning lawyers all the time, and I wanted to not spoil the game for the lawyers, but also say that just like it happened with GDPR, I happen to be a privacy professional and I have a political science degree. As long as that person is well versed in back then GDPR, but now I guess also with the AI Act, you don't need to be a lawyer. You need to know your game, and and so I think hiring for privacy professionals in the past, especially since GDPR took effect, has shown that in practice that person does not have to be a lawyer or have a legal degree, but other degrees can be super helpful. And I think that is even more the case for AI, because it's such an encompassing technology that actually a lot of other degrees have value, and you just need to know the regulation really well and how it's put into practice. So just making sure that you don't think you need lawyers, and because lawyers have much higher hourly fees than other professionals and privacy professionals, for example. And I'm not making the case here for me because I'm not available for that. But yeah, just make sure that you know what you're doing and look at other degrees as well.
That's true, and I think the main takeaway also is to say that you need a good team. You need to have some compliance team in place, and it needs to be comprised of both people with an ML background and people with some legal understanding, be they lawyers or whatever, people who just read about it. But there needs to be somebody in charge, or a team in charge. And we had a question there too.
Yeah, sure.
But yeah.
Yeah, so for the audience at home. Come again? Mike is better for the audience at home. Right, yes. So, hello, my name is Eckhart. I used to be a lawyer. I'm a software engineer, and so I see both perspectives in here. So to be honest, I agree with what has been said before, that when you are well-versed in, in the matter from a, let's say, self-study point of view, you can do a whole lot of things. Once you really get into legal issues, with a little bit of smartness and hard work, you can do a lot of things yourself. And then obviously, if you have a lawyer just, having some oversight, you save a ton of money. What I'm more worried about, to be honest, are the technical measures. Transparency, documentation is one thing, but technical measures, I just like to remind ourselves of GDPR. So in the Wild West days, we could just send out whatever marketing things we did and wanted, and we would track people on a website. We created hash, and we would identify them cross platform and cross websites. And there were so many attribution providers, and all of that has essentially gone away with the GDPR. Now, to remedy that, direct marketing companies, had to set up separate entities that were legally independent, creating a complex system that uses cryptography and hashes and to cross-reference without revealing the identity and all of that shit, simply so that I get another stupid letter in my postbox simply because I actually went to some website. That is still possible under GDPR. Now, if any of that comes to the AI from the AI Act, then I really wonder, what do we have to do from a technical perspective? Because it is still very vague, and I would like to see what is actually what we have to do. But if we're heading down the route of GDPR, I have no idea what costs will be involved and what effort, and it might well be that we burn 3% of the budget onto lawyers and 25% on engineers who do stuff according to the I Act. Is there anything that you can say about that? What's down the road?
There is, well, one thought that comes to mind is that there is a study that was done by the Future Society where they looked at the costs for actually training a foundation model. And that was a 10 to, I think, 23 foundation model, so not even like top notch, or 10 to 24, I think it was. And that they found that, you know, by average layers and so on in San Francisco company, blah, blah, that costs you about $60 million. And the compliance costs for complying with foundation model rules in the AI as they were conceived back then, which was even harder, this was 28B, would have been 1% of this. So if you're developing like really high-end stuff, then you have to have a lot of money in your hands anyways, because it's just so hard and so expensive to train these large models that's going to be feasible, or you have to allocate that, but that's not going to be a budget problem for those guys who have that kind of funding. But it's, of course, a totally different game if you're small, because as Rasmus said, you know, many of these things, they apply to you being a small or a large company. Doesn't really matter, because the model that you're hosting or that you're building could be super complex, even if you're a small company, and it could be just in a high risk area. And then you still, all this applies to you, and basically you have almost the same compliance costs or almost the same compliance, say, efforts that are necessary, but from a much smaller team. So that's where I'm concerned that this will have, that this could have counter productive effects, or at least anti-competitive effects, to the extent that, of course, all regulation favors big tech, right?
Yeah, I think maybe double click on this, because I think that's an interesting perspective, right? Because the EU is trying at a lot of points, like to, even the US, like trying to deal with big tech and their dominance in many spaces. And I mean, from this perspective, especially here, you know, for like a big tech company, it's not a matter to comply with all this, and also to prove out that they're compliant. They'll just like spend a lot of money on legal and compliance and everything, and it's a small fraction of their total cost. Whereas for startups, it's hindering. So what's the thinking around this? I mean, people are smart, like drafting this. So have they not seen this, or is there just no other way to deal with this? Or could there have been more exemptions for smaller companies? Like what's your perspective on this?
Yeah, I think that's a really good question, and there's no easy answer to it, I think. On the one hand, a lot of groups in the negotiation process were quite cognizant of this, but oh, is there a problem with the mic? Can people hear me online? Can you just double check that?
Yeah.
Okay. So I think there were several proposals that were flaunted. One would have been to just plainly exempt SMEs from some specific obligations. This was actually in the original proposal of the Commission, where, for example, they said for credit worthiness, for credit scoring, SMEs would be exempted. And this is something that did not make it into the final version. But what you have is that for SMEs, the compliance burden is a little bit lower, because you would say that the compliance efforts that you need to undertake to fulfill your duties must be kind of proportionate to the size of your company. And also in the fines, this will be taken into consideration. So first off, could be a fraction of your turnover. And so if you're small, you don't have to do quite as much as Google or Aleph Alpha. And also second, you're going to be fined less. And let me also say, until you're fined, that's a long way. Usually, you know, first the authority
either IPO'd or dead, I guess, at that point. You're either IPO'd or you're dead as a company anyway.
Okay. Well, no, what I'm saying, basically the authority would usually come to you and say, hey, look, guys, there's a problem. Can you try to fix this? And if then you say, you know, we're not doing anything, well, we don't care, we just want to sell a product, well, then, you know, over time you might get fined. It's not the fact that actually you're doing one mistake and you're immediately fined 7% of your turnover. No. But that was one thing. And the other, my idea would have been to say, you know, help startups get liability coverage, liability insurance, for example, and help them in some ways, because from a consumer or from fundamental rights perspective, it's difficult to say that only because a company is small but still engaging in something that's potentially harmful, you exempt it fully. But you could say that, you know, the compliance efforts, they're a little less, and that's the case at the moment. Plus that you give financial support to these companies. So I think we need this whole other part of the equation whereby, and that's something I've said time and again, and the government's starting to listen just a little bit, because there are some initiatives out there now that we need much more on the funding side, on the supporting side, where we get non-bureaucratic structures in place such that people can actually get help with, you know, hiring a compliance team, can get help with building a pilot for and testing it out there, not necessarily through a sandbox, and we can talk about that later on too, but, you know, just in a very pragmatic way, getting easy financial help. Because I think that if we're not doing this right, Europe is really going to be lagging behind, and that's a major geostrategic problem, and it's a major economic and social problem. And so we need really billions of euros. I think we should, you know, EU should take something like 10 billion euros and say, now we're investing in our future. Now we have this safeguard thing, the AI Act, but now within it, let's build something. And we need a whole lot of money for this. It's not, you know, it's not like 100 million. And yeah, that's, you can build an Autobahn with that. But no, I don't know if we're going to need so much more of that.
And I mean, like related to that, I think like, I mean, and also again, making the comparison to GDPR, I mean, like a lot of things here and also in GDPR are very sensible ideas, make a lot of sense. The biggest challenge we've seen with GDPR, also with some of the companies and applications we've building, that on the customer side, you know, especially if you're selling to SMEs, there's maybe sometimes not full understanding of, you know, is this now fine with GDPR or not? And there's uncertainty, and that slows down sales cycles, and that lets you grow your revenues not as fast, or maybe not close some customers at all, which ultimately on a global scale will be a disadvantage. So I guess how can we make sure also now in the coming months, with all the you know, things that become more concrete, but also maybe by setting standards to ensure that this is not happening again with the UAI Act. So that actually basically, you know, when a customer sees a product, they can within like minutes ideally say, okay, yeah, no, I can trust the AI side. It's all like, and it's hard because it's a hard problem to.
I mean, it would be great to have an automated tool, and there's some. I know that there's some initiatives for automation for at least classifying AI systems. So first of all, to know whether you're using an AI system or not at all, because that's one of the problems where it's also very vague. Actually, if you look at where's this my problem sheets. So part one of the problem. This is the definition of an AI system. You know, it's a machine-based under the AI Act. It's a machine-based system with varying degrees of autonomy. Now that's very concrete. And that may show adaptiveness after deployment, that infers from input it receives how to generate outputs. So it has inputs and outputs. That's very rare among algorithms. That can influence physical or virtual environments, also very rare. So I asked myself the question, you know, if you have a case with Excel AutoSum, is that an AI model according to this definition? What would you say, ladies and gentlemen? And why or why not? No, why is not? Well, it has a varying degree. You know, it's not a single, varying degrees is basically saying nothing, because varying, yeah, okay, it doesn't have autonomy, yeah. Oh, but most AI models are deterministic. So that doesn't matter. If it's not a probabilistic model that has some randomization feature and it's deterministic. No, not most don't. Generative AI has, I think, or if you give the same input, gets the same output. So that's deterministic. But anyways, you're right. I mean, autonomy, you could say it doesn't really have any autonomy. If it needs to have varying degrees, probably 0 degree of autonomy wouldn't count, right? But still, it doesn't say that, you know, if it's very little autonomy, it would still, it just says there are varying degrees. Yeah, that's a non-starter. I think the point where it would break, yeah.
About the definition of AI, one perspective out there is it's vaguely kept it's intentionally kept very loose in order to future-proof the definition of AI and keep it too broad. Is that correct? And the question to you, Rasmus, would be, what do you think would be the implication of such a broad definition on future innovations when they are pre-regulated?
Yeah, I mean, I think you're making a very good point. It's so broad, it could mean anything or nothing. And I mean, we can come up with like 10 stupid examples which should not be under this regulation. At the same time, it's probably still certainly better to have this very vague regulation rather than having something that is too, or vague definition than something that is too strict and maybe is later harder to adapt, because I guess a lot of the actual like ways of interpretation of this and the use cases will come later when there are some rulings and maybe first court cases. But it creates a lot of uncertainty, right? Because like as the same way as we like disagree here in the room on some things like should they fall under AI regulation or not, and like where's the line, like everybody will have this problem, and also every customer and also every investor will have this problem. So it will ultimately create uncertainty, which is never great when you think about it from an investment perspective or from a customer perspective, should I buy a product. So I think at the same time, we can't get around fully. I think there needs to be some regulation, but it's certainly not advantageous now. And I think the most important thing from my perspective is that we are quite, adaptive now in the next couple of months in terms of, creating really good examples, also having the regulator say, look, like this is okay, this is not okay. Here are like 10 examples, having very concrete guidelines so that it's really easy for even the smallest AI startup to read this material, implement it, get it done, and also show it to customers and investors. So if investors ask like, AI Act, am I fine? You can refer to that and they can understand in less than half an hour that you're actually compliant with that. And I think we need to get there very quickly. Yep. Because these litigation, like court cycles, as you said, are so long, like it's a different time scale than kind of venture funding cycles, right?
And just to, on that point directly, or if you have a different question, maybe let's just, yeah.
And also, why restricted to AI? No, what makes AI so special? Why not? If I look at the different fields, health, education, I mean, don't we want secure and safe software with a human in the loop for all kind of IT? What makes AI now so special that we have this special law for AI?
Yeah, that's an excellent question. Also, I think that let me first answer that. Try to answer the question about the Excel AutoSum, and then we'll get back to that, to your question around here. So they did provide some guidance in the recitals, and what they say is basically what makes AI, I think, is here the term inference. It infers something, and that the recitals. So for everybody, the recitals, that's part of every EU law instrument. It's not binding, so it's not the articles, which would be like the Paragraphen in Deutsch or something, but it's basically preliminary observations, but they're generally used by authorities and by the courts to determine whether something falls under the illegal term or not. So here in the recital 6, it says inference goes beyond basic data processing, and they say, well, the following system is not an AI system. That system's based on rules defined solely by natural persons for the automatic execution of operations. So that's, I guess, what kicks out the Excel AutoSum, because they were cognizant of the fact that, of course, this is an extremely broad definition. It's actually the revised OECD definition of AI, which is a funny thing, because if you don't say anything more about it, you could say that any kind of calculation is also kind of an inference, so then this is really a definition of software. And this brings us to the point, what's so different about AI than software? And I guess one of the things is that it works on data, which software not necessarily does. I mean, it's trained on data. And that has special implications because it's actually, the data could be skewed, could be biased, it could be more intransparent. It could also be the case that it's unforeseeable, which is perhaps something that we were talking about before. It might be deterministic, but still unforeseeable, because you might not know how the system behaves in certain edge cases, which might be different with software. But again, there could be complex software where the same holds. So I think it would have been wiser to just go for a complex software act rather than an AI act. But that would have been a totally different regulation, or maybe not so different, but it would have been designed a little differently. By the way, the Product Liability Directive, that applies to software and AI, but the reversal of the burden of proof specifically to machine learning. and some other scenarios if you violate certain rules or if you don't comply with this request for data, then there will be a presumption of that.
Can you maybe go into this liability, or maybe we do the question first?
Yeah,
Yeah.
but my question's a little bit off. So if you want to,
No, that's mine is also like mildly
Okay.
related only, so.
yeah, it's more about the timeline, and maybe I didn't understand the article correctly, but I think that it basically says if you have a high-risk system that was developed before the 30th of January this year, and it's not used in like government context, the AI doesn't apply. And first of all, I want to know if I understood that correctly, and second of all, I wanted to ask you if you think this could create some loopholes if I build a system which is like nice, high risk, but then it's like was built last year and then doesn't apply. I was very surprised when I read the article.
Which article was that?
I think 38.
Oh, you mean the article as in it's 83. Yeah, that's correct. So this is one thing that I didn't mention when I talked about the timeline, but it's actually true that what about existing systems, right? And usually in product safety regulation, doesn't matter if your existing system or not. You know, you want cars to have seat belts, and it's no excuse to say, hey, I was already on the market without a seat belt before. You can't make me, manufacture a seat belt right now. So same theoretically should apply to AI, I think, where you can say, hey, already you usually have an advantage if you're on the market, and now to exempt that model makes little sense. But that's what they opted for. I mean, it's a big compromise with a lot of industry lobbying, obviously. So for foundation models, if you're already on the market, then you have 24 months to comply. And if you are a high-risk system, then indeed, and you're on the market, you're not covered by the AI Act unless the system is significantly changed afterwards. So you cannot build a system now that will forever not fall under the AI Act, because most likely you will have to do some significant updates. But it's true that if you have and I was totally struck when I read this, and I read it again and again, but there's no nut that I forgot. It will go through the lingo check, so maybe there was some error in it, but at the moment that's the case. So if you have, and that's interesting because it means and that's perhaps something for investor perspective. You build something now and you bring it out, and I think the cutoff date is really the moment the AI enters into force, which would then be sometime when it's published. Nah, it is something. I'm pretty sure that it's actually when it enters into force, but we can double check. It's you can read Article 83. It's I think paragraph 3. Or subparagraph 3, then basically if you go on the market now, then you have a significant advantage because the AI might not even apply to you unless you change the model significantly. And so this is something you can basically sell right now, creating potentially more moat around companies that are already on the market vis-a-vis those that are starting from this summer on.
Let's maybe talk a bit about some of the like kind of future topics also, like the things you're working on right now. So I mean, there's a few topics I'd like to touch, but maybe you have some others. I think like one is how will this whole like liability topic like further develop? Maybe let's start with this, just because I guess there's also like different players in, right? There's the foundation model companies, there's the people building the application. I mean, yes, there's the directive now, but like, how do you think this will play out in practice? Because I guess it's quite a fine line who is ultimately liable. It doesn't make a difference then for the consumer, right? But like for the companies, it might make a big difference.
Yeah.
And it also has to do with, I guess, the UAI Act in terms of like the transparency of like what the foundation model provider needs to provide to the one building the application. And there's a trade-off because I guess if they don't take any liability, nobody will want to use their product, but at this or their model. But at the same time, if they are liable for everything, that's also probably not in their interest. So how do you see this balance playing out?
Yeah, that's a great question again. So with liability, the way it works usually is in product liability, everybody up until that contributes up until the end product, and end product would be the product that is then brought onto the market. Everyone is liable. So say you have a car and you have somebody who's manufacturing the tires and somebody who's manufacturing the steering wheel, and then the final company puts this together. If the wheel blows up, then both the final manufacturer, say whatever, Mercedes, and the tire manufacturer, they're both liable, but not the steering wheel manufacturer, because that didn't contribute to the thing that was exploding. If the steering wheel blocks, then it's the steering wheel manufacturer plus Mercedes again, plus the final one. And that's the same system here. So it's always the component manufacturer and the end product manufacturer, and they're both liable. And in law, we say jointly and severally. So basically, that means that the consumer can sue each one as they please, and then they have to figure out between them who is ultimately liable.
So I could go also to NVIDIA, actually. I mean, they have a lot of money, right? Like, is that where I could even start?
Well,
or
if it's the chip that it's defective, yes, but that would be hard.
But
to
as a
prove.
consumer, I mean, like initially.
Yeah, if the chip is defective, yes, but it's hard to prove that. It's unlikely that the defect will be in the chip. So you can only sue the end product manufacturer and the component manufacturer whose component was actually defective. Otherwise, yeah, if you can't sue NVIDIA, please do sue NVIDIA, I guess.
But how do you think this will play out? I guess, like, if the model, like, you know, the product makes some mispredictions, something really bad happens, like, I guess, where do you think people will go?
So, of course, consumers will go, or lawyers will tell the consumers to go where the deep pocket is, right? So it will, and that will depend. So it will depend on the case. So it could be that it's a really small company that has bought a piece from, say, OpenAI, Microsoft, whatever, and that you would always sue everybody usually, but you would try to recover from the party that has the deepest pocket. And that's basically, I guess, for SMEs, that's not such bad news, because first in line are going to be those with big names, because you know that most likely they will have, you know, you will be able to recover from them. But then they could turn around, and that's going to be the funny game between the businesses, basically, to see who's ultimately liable. And this will be the party that actually violated something. For example, violated the AI Act, or violated some other safety rules or best practices or something like this. And this is where I guess, and that you could also regulate contractually. So this is an interesting phenomenon to watch, whereby, of course, larger companies could say, hey, you can use our products, but you're not going to sue us, right? You're going to take all the, you know, all the shit in the end. So this is something to watch, basically, because there's only limited oversight over these contractual liability clauses and contracts between companies. And so this can get pretty complex, actually. And I've seen that there's a question, but just one side note to this. The funny thing, or one of the unsolved problems, I guess, is who's liable for generative AI? Because so far we've been talking about, you know, mostly products. You know, you have a cancer recognition system or something. But if you have a generative AI product that just puts out, you know, one of my favorite, it's not great that we have this, but, you know, one slide that I want to show you is this, you know. ChatGPT invented a sexual harassment scandal. It's a real Washington Post article, you know, named a real law prof as the accused. It's not me, but it's a colleague from Georgetown, and this is pretty bad, of course. So yeah, and what happens if this comes out, or something else where, you know, the chatbot insults somebody? Who's liable then? And this is super tricky, because under general jurisprudence of the CJU, this would not count as a product. Everything that's information is usually not a product. So product liability doesn't apply, which means, and if that's correct, and it's not clear whether that's correct, but that's at least the current jurisprudence. But of course, they ruled on newspapers, not on generative AI. For newspapers, that's clear. There's a different thing. There's a difference between the newspaper as such, the thing that you touch, and the information inside. With generative AI, you might say, hey, the information is generated by the very product, which is not the case in the newspaper, of course. It doesn't write its own articles. But so then it would be member state law, basically the law of how to, you know, the law, Äußerungsrecht, we say in German, so communication law, speech regulation, which first of all differs between all 27 member states in the EU. And second of all, is really difficult to foresee. I would say, most likely what's going to happen is that courts might look at what they've decided before. What did they do in Germany? There's a case called the autocomplete case. Does anybody know the autocomplete case? The lawyers? Yes, Julia knows it. You're not a liar, but she still knows it. Excellent. Very good. Yeah, basically, so autocomplete is basically, I think it was even this case about the wife of our former, Bundespräsident, and you typed in her name, whatever her name is, and then the first thing that showed up was, prostitute, and I think she or somebody else, and she also joined. They sued them, and autocomplete, of course, they're basically small language models. Correct me if I'm wrong, but it's basically prediction of next token, and so that could be a really nice parallel. What did the BGH say? So it was Google. Google was sued, and Google said, "Hey, come on, we're not doing this. They're typing this in, and we cannot control each and every whatever." And then the BGH said, "Well, you have to take reasonable precautions, and that means, for example, if you get a heads up, this and this name is put in there, and then the first autocomplete is always prostitute, then you have to disable that." And a similar is basically notice and takedown, which we know from copyright law, right? And so a similar system could apply here, where you say, hey, if you're an AI developing company, developing generative AI, basically you have to be able to disable certain things if you're put on notice. And similarly, I would even say, reasonable precautions that will also apply to those just using this in their company, consumer facing. So basically you have to be able to say, well, first off, I chose a model that has, let's say, reasonable safeguards, not a totally unmoderated one. Second, I did perhaps randomized checks to see that it's not spewing out to total hatred or whatever. And third, if there's a complaint, I did react. And I'm reacting by either disabling the function, or if I can't do that because it's hosted somewhere else, I'm at least calling the host, the provider, and telling them, look, guys, there's a problem, please fix it. Might be difficult to fix, but you may have to fix it. Otherwise, you might be liable under this. So that's a whole different scenario there. And Julia has a reason, an opinion about it too.
Forgot about it. Thank you. I happen to be visiting the section of Google search just after that verdict came out the verdict came out in Germany, and I was in Mountain View with a group of German journalists and some politicians, and they asked that main engineer from Google search about the Bettina Wulff case, and it had made the news had made its way way into to him, but it was obvious how confused he was about that, and how totally clueless he was about that, at the time, how to technically implement such a thing, because he was only thinking in probabilities. And I think that's a really important jump that those engineers have to make. Well, we're not talking about statistic probability here, and of course, at that time, the year before or so, Bettina Wulff had been called a prostitute in some news articles, and of course, then you could say, well, statistically, that's the answer is right, and but to think about consequences for people and legal consequences, but also personal consequences and what impact they have. And I think that was really interesting to see how then, as a consequence, they found a technical solution to that.
Right, and sometimes the technical solution is really to just take down a feature. So for as much as I know, the problem that some Black citizens were, African Americans, for example, were categorized as gorillas in Google Image was just, they just abolished the gorillas and another chimpanzee or something, another ape category, because they just couldn't technically fix it at that moment. So, but that's just, again, goes to show that there is this complex web of using technical insights and legal stipulations whereby you might have to come up with a decisioning system such that you're not running the AI unmoderatedly, but you have some lexical rules after that just block certain stuff. I mean, nowadays that has become standard, of course, with Gen AI, so that you don't, if you asked it, how can I kill myself, it won't give you an answer usually. But that's something that you have to keep in mind when it comes to this Gen AI liability field. We have a couple of questions there.
Let's do some of the questions. I think we have a microphone there. Maybe you
Sure. So my question touches more the liability part, and especially in the context of startups. So startups usually have a pretty hard time selling to enterprises in general. And if they sell to enterprises, the hurt is quite hard. And if, in addition to that, the enterprise is looking into the UI Act and putting the hurdle even higher for those startups to sell their solution to those enterprises, do you think it will have consequences, the UI Act will have consequences that it somehow shrinks the market or makes it difficult for startups to even sell to those large enterprises in general?
I think there's no denying that, any regulation, and that's well documented for the GDPR as well, just favors bigger companies. There's little you can do about it because there's just, if you have more experience with compliance and you have deeper pockets, you're going to be at an advantage. But that's holds for so many things, right? And still, startups sometimes are more agile, smarter, and perhaps better in implementing a lean compliance system, for example, trying to automate it because they're under enormous pressure. So yes and no. I don't think there's an easy answer to it. Certainly, it's going to be more difficult for SMEs. Absolutely, no doubt about it. But maybe, somebody comes up with a smart solution how to automate a lot of this stuff in a fairly reasonable way. There will be checklists, of course. There are checklists out there already for different parts of AI, like responsible AI management. You have the AI checklist from the AI from the high-level expert group. It's been out since, I think, 2020, high-level expert group to the European Commission. And those are some of the things that will develop in this ecosystem as well. And hopefully SMEs will be able to, use them in a smart way. But I think in the end, yes, it's not gonna make it easier. Yeah.
Yeah, I think I have two minds there. Like one mind is like complaining about this all the time to make it like less painful for companies. That's kind of my I guess like way of trying to push against this, and I firmly believe like it is a big disadvantage for early stage startups, and that's not what we want, especially in these areas where we want AI applications, some of these high risk areas. That's kind of, I think, so it's good to push against it. At the same time, I think it's also really bad to complain all the time. So in the end, we also need to just build, give concrete examples, make it very easy to understand why we comply with the AI for a certain product, and be convincing to the customer and be pragmatic about it. And I think a lot, when you also realize like the slides you showed earlier about like, correctness and bias, and like the definition is on such a bird level right now that I think for a lot of the things, and Philipp said that also very often, like if you are reasonable and like documenting and you make like reasonable design decisions, which I think pretty much everyone I talk to, is trying to be reasonable and actually very cautious about like where they set certain threshold and what their data set looks like, and if their system is robust and that they test systems properly. I think also, in the end, the worst case that can come is that you have to go to court and people look at it. And I think if you are reasonable all these stages, then decide things with a good like ethical like mindset, then I think you should also be fine.
Just to chime in on this, just one slide that I wanted to show lest we forget it. So this is for AI users, you could say AI deployers. So this is for people that are not building AI systems, but they're using AI systems that have been built by others, right? And then remember again this problem about if you make a significant change, you're not a deployer anymore, you become a provider. But deployers or users, basically, they now have a couple of rules under the AI Act. And some of them are new, but most of them already apply under tort law, right? Under just general rules of the marketplace. So monitoring and supervision. Of course, you cannot let an AI system just run unmonitored and unsupervised for ages. I mean, it's just plain common sense. Like you can't dig a hole somewhere in the middle of the street and say, hey, traffic, just come along. I'm not going to put up a warning sign there. That's just plain common sense, right? Same for data governance. You can't put crazy data in there. Well, yeah, you don't. Information documentation, that's the main thing, right? You have to document it well. And there's one thing that I think is interesting and that I perhaps want to show to everyone, this decision notification in case of high risk, because this is something new that wasn't there. So if you are using a high-risk AI system, then you have to inform the affected persons about this, even if it's only decision support. So say you're using AI for recruitment purposes, and you're not even scoring the individuals, but you're using it mainly before as a screening device and only as a recommendation, and a human takes the final decision. Even if it's only in this assistant function, you have to tell people about it. And I mean, the extent to which this will be complied with, I don't know, but at least if people take this seriously, this is actually interesting, because many companies, I think at the moment, particularly in HR, they try to hide the fact that they are using AI because it might have reputational consequences. So this is going to enter the game then, whereby if you're using AI and in a high-risk scenario and it has effects on people, you have to tell them. And so that's just one thing that I wanted to highlight, because that's really different from what we have before. There's no rule that I know of that mandates this across the board at the moment.
I have a question about how you turn this into practice. Just thinking about how AI development or AI system development works at the moment. Like, you pull together a lot of different components, and these components are typically not like wheels or steering wheels that you purchase from someone, right? It's like, we're living in an open source world. Like, a lot of things are just used in a different context with different data during inference. So typically you don't have the same kind of accuracy or data cleaning, denoising during inference that you have during training, because you don't even know what exactly they used for standardization of this data. So two questions from this. One, what about the open source world? Who is liable there? And the second, on the chain of responsibility of chain of liability in all of this. In the end, like, what do you think, how will it be in practice? Is it the OEM, let's say, of the future, who just puts together the components and builds the AI system, and then they need to prove, oh, originally it came from a model that I used? Or can they just like deny it and say, okay, like, we used that model, and somehow they report some accuracies for these certain use case? In the end, it's not our business, it's their business.
Yeah, that's a really good question. So first off, I mean, the consumer-facing company will always be liable, right? Because there's no denying in that you sold that product if your name is on it, right? So there's always going to be liable, and those companies have a very keen interest in documenting what companies they're collaborating with, and whose companies, whatever data and products and you name it, or features, components, let's say, go into that stack, right? And so I think it's going to be tough to deny, to just say, hey, it wasn't us, we weren't even in there. If some people know that that you were in there. But the real tricky question is about open source, I think. And so I can tell you what the AI Act says, and then we can have a debate about whether that makes sense, and the product liability directive. So this was also one of the big controversies, of course. And the AI Act says that open source is exempted, but then it's not exempted for a number of things. Actually, for almost everything. So basically, open source, if I'm not mistaken, is only exempted if you are an open source foundation model that is not systemic risk. So basically only llama. Everything else is not exempted. Because if you're an open source system that's being used in a high-risk context, still applies. If you're an open source model that's being used, that's a foundation model with systemic risk, still applies. So the only basically loophole where open source really gets an exemption is foundation models without systemic risk. Basically any foundation models that are less than 10 to 25 flops, or the commission could even say, well, you're below 10 to 25 flops, but you're still pretty risky. But for that, I mean, that would be quite a judgment call, and they will look at the effects and so on. I guess if there is a major incident with, say, Mistral Large that was now released, that's close to GPT-4 apparently on many benchmarks, but they probably used less than 10, 25 flops. I don't know, but I suspect they could, if there is an incident with this, you could say, oh, maybe it gets designated as systemic risk. That's under the AI Act. Now, what about the liability thing? Because I guess there's two hearts in our chest, right? On the one hand, I think most of the people that are somehow involved in tech are fans of open source, because you just can't do things without open source. And it's also a force for good, and that it decentralizes everything, is against monopoly and whatever. On the other hand, of course, there's this problem that if there's something, a bug in the open source code and gets replicated everywhere, and then you have these heartbleed phenomena and so on. And also, of course, with open source foundation models, you can do all kinds of funny stuff if you're, you know, a terrorist, and you can reverse it and you just take out the security layer fairly easily. So for the product liability directive, the result is that there is an exemption, really full exemption of open source, unless it is used in a commercial application. And then that person or that entity that uses the open source is responsible. So basically, you have to double check if you're integrating open source, you have to basically check that it's fine to use it. And if not, you're assuming liability. And depending on the terms of use of that open source thing, you could turn around and try to, you know, sue them, but if you even know who that was and whatever. So it's going to be tricky probably. So liability wise, it's most likely going to be the commercial entity integrating the open source, and they just have to do due diligence, but also for their own good sake. I mean, you don't want to sell shit, so you don't want to build with shit. So I guess that's, again, standard practice. Although I have to say, I don't know, maybe people start using all kinds of stuff because it's just handy and they just need a solution for something. I don't know. What's your take on this?
I mean, like, I also think like a lot of it will be with the company developing the application, because that's the one that ultimately the consumer interacts with. That's the one that, because probably the use case is quite specific, you know, only then later figures out what maybe the product was used for. So there's a lot of scenarios you can go through where ultimately it's hard to blame it, I think, on the foundation model provider, which I think is also a problem, right? Because like ultimately also, I guess many here in the room are on the application side, building applications using foundation models. So ultimately it comes with their liability, it comes with them that they, you know, might get in trouble. And that's also interestingly not necessarily in the interest of big tech, because people want people to use their models. So they're also fine to take some of the liability. But I think there's some tension. Like you as a company, if you don't take any liability, like nobody might want to use your product. But if you have all the liability, it's also not very, very sustainable. So I guess it will balance out, and we'll probably only find out over time.
Yeah, and you've probably seen that, for example, Microsoft, of course, made that bold move and just saying, you know, we're covering every user for all the copyright claims, which I told the Microsoft lawyers, hey, that's a bold claim to make. Then came the New York Times suit, and I was like, let's see about that. But that's a different issue. Like the copyright would merit a different discussion. It's also super interesting, of course, but that's, yeah, another set of roles.
One last question here. Yeah, that was meant to be my last question, copyright, but I think it's for another session.
Okay, we have another 2 hours.
Thank you so much. So what would you say? How competitive is the EU for an AI founder? And did it become more competitive or less competitive since the AI Act came, or since we know the final draft, like not only versus the US, but for example, the UK as well? What would you say?
Yeah. So I think to a certain extent, it hasn't necessarily become less competitive because it was already priced in. So we've known about the AI for quite some time, and I think it has had fairly negative repercussions across the industry, and particularly the investing space. But you'd be in a better position to talk about this.
Yeah, I would also say like slightly negative. I mean, I think a lot of people have been very vocal about like trying to push it in a more sensible direction. But ultimately, a lot of that has already been priced in, and I think in practice we also see how big the actual impact is, but I think it's certainly not making things more competitive. Like I think that part I just don't buy. I mean, also seeing from previous regulation or any regulation.
But on the other hand, it's also not as bad as it could have been. So most of the things are fairly, I'd say, sensible in the sense that it's basically industry best practices. There's a lot of uncertainty around it, but that's just a bit of a time issue, where if we get more guidelines, we get more case law, then that will be partially resolved. What I think is missing is this other push in the other direction, saying, okay, now we got this regulation, now we got the guardrails in place. Now let's talk about, you know, attracting people, attracting investment, attracting founders, attracting actually AI to the EU, not just any AI, but AI that is safely and responsibly built and sustainably built. So I think that's one of the future topics where we really need to think about, we have a burning planet and we want to make sure that AI helps to solve that problem, doesn't exacerbate it.
I mean, that would have been like a very easy move for the EU to say, look, like here's the EU AI Act. And by the way, here's like some investment for high risk applications. Like, yes, we want to regulate this because it makes sense, but at the same time, please build in this high risk area because it's important. But that narrative is just missing. And I mean, I don't understand why. Like it was also, people were quite vocal about it, but I think that's just not the narrative, unfortunately.
Yeah, I think the narrative, that's perhaps the biggest pain point. It's difficult to change now. People are trying. So in Germany, we're going to have this 1 billion fund for deep tech and sustainable investments. And some on the EU side, they're launching a couple of bigger projects, but it's also scattered. It's not a single entry point where you could say, hey, look, this is the 5 billion, the 10 billion that we need. It's all scattered across many different things, and it comes usually with so much red tape that it might be difficult actually for particularly smaller companies to apply that, because then first you need to hire somebody to actually administer all this stuff, and then you're spending half of your money on administering this. This wouldn't be the good.
Yeah. But it's also not good to complain all the time. I mean, in the end, you can start building, and there's still so many opportunities. So yeah, with that, I think we are out of time. Went quite long, so we'll also be around for some time. So if you have some more questions, let's discuss. And also, there's a lot of interesting people here in the room, so also to discuss among each other. I think we have some more drinks, so stay around. Thanks so much. Thanks, Philipp.
Thanks, Rasmus. Thanks for having me.